be restricted from obtaining a final decision of EFF versus the Speaker, National Assembly. And we say, and this is the quote from paragraph 235, and ironically they also refer to this in their heads, Your Worship, in the middle of 235, it is after all the embodiment of the legendary Lady Justice, a dispenser of justice who is blind and deaf to images of any reports on the good reputation or notoriety or personality before her, but never misses any legitimate and relevant legal or factual points for or against any litigant. And then this court is required to always display the critical boldness to go against overwhelmingly popular and forceful opinion. And then we also deal with the Constitutional Court decision, finally, Your Worship, of Senwedi. In paragraph 27, 2022 decision, it says, our courts must defend and uphold the Constitution and the rights entrenched in it. One of the most important rights from a historical perspective is unquestionably the deprivation of an individual's liberty. The court said in February that conceptually, individual freedom is a core right in the panoply of human rights. The apartheid regime repulsively and capriciously deprived people of their freedom under illegitimate legislation that paid no respect to the rights to freedom and security of the person. We are therefore constrained to jealously guard the liberty of a person under our Constitution, particularly in terms of Section 12 of the Bill of Rights. So those were the cases that we cited, Worship, on general principles relating to sentencing. We then turned our attention, Worship, in our heads to sentencing concerning firearms. And we had regard to the article that my little friend had provided to us of Dutoy, relating to a note on sentencing practice for the offence of the unlawful possession of semi-automatic firearms, and that's what they had utilized the support that there should be a period of incarceration. And we quote from the report, Your Worship, and we say, and I'm just quoting the second paragraph here, from the investigation it's evident that courts are more likely to impose the minimum in such cases, little attention is given to the firearm-related offences, as the courts are more concerned with the cumulative effect of the sentences imposed on different counts. We also then refer to the decision of ASMA. That's on the next page, where we say, from the Supreme Court of Appeal's judgment in ASMA, it appears that the circumstances under which the unlawful possession occurred and the purpose for which the semi-automatic firearm was possessed will play a pivotal role in determining whether substantial and compelling circumstances justifying the imposition of a lesser sentence exists. There's reference to Delport and the gradation, which is also referred to in their heads, and that there's a quote there, the grading of the offence will typically be informed by the risk of harmfulness and the culpability of the offender. We then make the bold submission that I've already made to Your Worship, that the minimum sentence regime does not apply in this instance, and that's at paragraph 29. We also refer to State v. Marikani, which the State has referenced, and we quote from that decision. But we say what is notable from these cases is that imprisonment is not always the norm. And then we say as follows, that, turning to paragraph 33 now, that the case law, we say, sub 1, the circumstances of the possession are a central factor. If the context of the possession is part of an overall commission of violent crimes, the court will generally incline towards a harsh sentence in keeping with the objects of the legislation. That's logical, Your Worship, and speaks for itself. If a firearm is used to commit a murder or to commit a robbery, it's far more serious than a firearm that isn't used to commit another serious offence, which is what we submit the case here. Secondly, the purpose behind the possession is also another factor that emerges from some of the cases. We say, while not decisive, it is a factor that a court may legitimately take into account. Indeed, there is a vast difference between an accused who has been asked to temporarily keep a firearm while the owner goes shopping and a person places a firearm in the boot of his car intending to hide it from the police. Then thirdly, the duration of the possession is a relevant factor. If an accused has been in possession of a firearm for a lengthy period, they cannot be treated the same. For sentencing purposes, as someone with fleeting possession of a couple of seconds. Fourthly, harm is a critical consideration. The court should consider what the harm is. We accept that possession is in itself a harmful thing, but there are degrees of harm caused by possession, so the court would need to satisfy itself about the harm it seeks to punish. Possession in celebratory context for a few seconds should be considered differently. That's our submission. And from the cases, Your Worship will also note from whom and in what circumstances the accused received the firearm also play a part. We then quote the Delport decision about Bin's ward about predation, which turned on the circumstances and relatively innocuous possession. And we then turn in paragraph 35, Your Worship, to cases on discharge of firearms. And we say that they also do not always attract incarceration, and that regard is had to the circumstances and the context of the discharge. We then referred to the decision of State versus Fulyun, which Your Worship will remember is the case where the person shot at a motor vehicle in a public area because he believed it was his wife's lover's vehicle, and he pleaded guilty and was convicted, given a fine. On appeal, even the monetary fine was reduced. Then the second decision that we quote there, Your Worship, which I've already referred to, is the Pistorius decision, where there was a shooting in a restaurant in Laos by the name of Tasha's. Under the table, there were over 200 people in a very confined room of a restaurant. Fortunately, there were no injuries, but there was damage to the floor. It was a Glock 27 pistol, and we said that's the most comparable to here, because we believe the witness was given his firearm back after the incident, and that he was the lawful possessor who had handed it over to the shooter, but they told him not to shoot. And we explained that in paragraph 37, Your Worship, that there were 220 people in the restaurant, so it was full at the time. That the accused admitted that he had taken the firearm because he was planning to buy a similar model. His version was rejected. But in that instance, Your Worship, the accused was sentenced by the CPJ to 3 years imprisonment, wholly suspended, and jailed. In respect of the conviction in count 3, which was the shooting and discharge of the firearm, I've taken into account that no one was hurt, though the offence is a serious one, especially in the setting of a restaurant. I do not believe that the degree of negligence in respect of this count, that is count 3, justifies a sentence of direct imprisonment. We then turned, Your Worship, and we went forward in time to the 2021. These are separate actions is in our view contrary to what is dictated by a common sense approach in view of the fundamental requirement of fairness and the misdirection. And there was regard also, Your Worship, as in this case, the appellant's perceived lack of remorse as an aggravating factor, and as regard had to the decision quoted by the state in the heads of argument of Hewitt.